Hello friends, in the series on the income tax cases, today we will discuss a very important case on the stay of demand. The name of the case is TRICHY District LORRY Honest Association versus Commissioner of Income Tax. This case has been reported in 455 ITR at page number 545 and the matter has been decided by Madras High Court. The date of the judgment is 25th February 2022. In this case, an assessment order was passed against the assessee in which a huge demand was created. The assessee filed the CIT appeal in time and the assessee also filed the application for stay of the recovery of the tax before the assessing officer and the CIT appeal also. The department did not give any answer to these stay of demand application and the CIT appeal also didn't decide the appeal of the assessee. But in the meantime, the department attached the bank account of the assessee and recovered an amount of near about 75 lakh from the account of the assessee. The assessee filed a writ petition in the Madras High Court for the recovery of the amount. It was the submission of the assessee that without disposing of the stay application, without disposing of my CIT appeal, the department has recovered this amount illegally and this amount should be recovered to me. When the assessee filed this writ petition, a very different type of judgment was given by the Madras High Court, which was not on the subject for which the writ has been filed by the assessee. First of all, the Madras High Court didn't give the refund to the assessee and relying upon a judgment of Supreme Court in the case of Principal CIT versus LG Electronics India Private Limited 2018, the High Court gave direction to the department to dispose of the stay application filed by the assessee and do not make a recovery of the balance amount from the assessee until and unless the stay of demand application is disposed of, which is filed by the assessee. Friends, my point in this case is that the demand is being created, stay of demand is not replied with by the department, recovery is made illegally, and even that when the assessee files the writ petition, the amount of tax which has been collected by the department illegally is not released even by going into the court. With due respect to the High Court, when this type of recovery will be done from the assessee, then there will be a great panic among the assessees after the demands are being created illegally, that at any time any amount which is lying in their bank can be recovered, and there will be always a fear in their mind that at any time this money can be taken away by the department, and the assessee do not have any recourse even from the courts nowadays that if the amount is recovered without disposing of the stay application, the assessee cannot get the amount back from the department for its business. The only relief which was given by the Honorable Court was that the court said that dispose of the stay application and do not make the further recovery until and unless your stay of demand application is disposed of by the department. One more thing, the case which was discussed in this case, which was related to the LG Electronics, in that case the Supreme Court has given the direction to the department that whenever you are disposing of the stay application, then do not keep in your mind the circular of the department which says that the 20% of the demand should be created, because this factor should not be kept in mind while the stay of application is being disposed of by the department, because it can hamper you from an independent decision on making the stay of demand application. But still, in spite of the very limited relief which was given by the High Court in this case, it is very painful situation for the assessees where the crores of rupees of demand has been created on the assessees and no action is being taken by the department for the disposal of the applications which the assessee is filing before the department, that whether it is a high pitch demand, whether it is a high pitch assessment, and even in the cases where the assessee is going for the high pitch complaint, in those cases also we are not getting the very good responses where the department is very active in disposing of the high pitch complaints. So in this situation there is a very peculiar situation for the assessee and very anxiety situation for the assessee to do the business, because anytime the department can take any amount of money from their bank account and there is no scope other than going to the writ court, and in the writ court also the assessee is only getting the relief of disposing of the stay application by the department as per the law. So whenever these stay applications are disposed of, the department does not take heed of the matter and does not consider the real difficulties of the assessee and the illegalities of the assessment order. At the end of this video, once again I am repeating the name of the case. The name of the case is TRICHY District LORRY Owners Association versus Commissioner of Income Tax Appeals and otherwise and the case is reported in 455 ITR at page number 545. The matter has been decided by Madras High Court and the date of the judgment is 25th February 2022. Thank you, friends.